All right. I'd like to thank everyone for joining us this morning and start by acknowledging the traditional owners of the lands on which we are meeting today. For me, it's the Wurundjeri people of the Kulin Nation, and I'd like to pay my respects to their elders past, present and emerging. We're very honoured today to have the Honourable Michael Kirby speaking to us about decisions of the High Court of Australia relevant to paediatricians. He probably needs no introduction, and I'd waste time by reading out his entire bio. But suffice to say, he's been a judge on the Federal Court of Australia, President of the New South Wales Court of Appeal, a Justice of the High Court of Australia, and he's held many appointments with the WHO for the Global Commission on AIDS, for UNESCO, UNDP and the United Nations, where he chaired an inquiry on North Korea for the United Nations Human Rights Council. He's presently the co-chair of the IBA Human Rights Institute, and I'd like to thank Michael for his time today.
Thank you very much, Amy. Well, good morning, everyone. I'm speaking to you by the miracle of Zoom from Sydney, Australia, and I am very glad to have the opportunity of speaking to an audience at such a famous hospital, Royal Melbourne Children's Hospital, and I pay my respects to you all. There is a convention in the law that judges don't talk about cases in which they have participated. The reason for that is that they might get bright ideas that they didn't have at the time they gave their decisions, and that their decisions have to be found in the reported cases where the decision is explained. So anything I say today is, of course, subject to the reported decisions of the cases. Also, I can't give legal advice. So when we come to Q&A, it'll have to be framed very cleverly to get past that barrier. Now, I'm going to take my starting point from something that it's pretty hard to avoid at the moment, which is the reaction of the public in the United States, or many members of the public on both sides of the debate, to the recent decision of the Supreme Court of the United States in the case of Dobbs against Jackson Women's Health Care. This is a decision that handed down in the last few days that relates in the United States to the law of abortion. It's an interesting and useful springboard to compare and contrast the way in Australia we have approached that issue and how they have approached it in the United States of America. Both of us, the Americans and Australia, have inherited a criminal law from England, and that criminal law is very ancient. It goes back to the 10th, 11th and 12th centuries, and it is a common law system, so that judges have a very important role in expounding, explaining and declaring what the law is in particular cases. It was by the combination of decisions in many cases that the common law of crime developed. It has undergone many changes, of course, in 10 or 9 centuries since it was established. The law of abortion is no difference from that proposition. In the common law, the approach was taken that it was not until the actual birth of the child that duties arose not to damage a fetus, and that proposition was in place at the time that the American colonists declared their independence from Great Britain. Indeed, in the recent decision, Justice Alito, a judge of the Supreme Court of the United States, said that embarrassingly enough, at the beginning of the American Republic, the criminal law probably did not have a proposition relating to the acts of abortion. However, both in the United States and a little later in Australia, in the Australian colonies, the criminal law did develop rather rapidly laws to prohibit all forms of abortion. And when I began my journey in the law back in the 1950s and 60s, when I was taught about abortion law, I was taken to section 32 of the New South Wales Crimes Act, which it was immediately alongside a series of provisions in the Crimes Act, and there were similar provisions in the Victorian Crimes Act prohibiting abortion and so-called unnatural offences. Because I was at that stage becoming aware of my own sexuality as a gay man, I paid particular attention to that part of the Crimes Act. And the Crimes Act prohibited all forms of abortion, both in respect of the acts of a woman seeking to abort, terminate a pregnancy, but also in respect of any person, including a doctor, who endeavored to help a woman to abort a fetus before birth. And it's interesting and informative, I think, that these two sets of provisions were there at roughly the same place in the Crimes Act, because they represented, in the view of some, an overreach of the criminal law, because the criminal law is dealing with the issues of the duty of each other to the community. And in the case of the unnatural offences, homosexual offences, that was a series of provisions that were dealing with the obligations of consenting adult persons acting in private. And the fact that there was consent, or that it was in private, or that the matter was something entirely between two adults, didn't matter at all. The criminal law intruded. In the case of abortion, the issue of criminal laws had really begun in England in the early 19th century, and criminal statutes were enacted which overrode the common law, the judge-made law. And those criminal statutes spread through the United States, but they also spread throughout Australia, and they were largely copied from the English model. And it's from that situation that the American people and their country and their courts find themselves in the current position. For many years, every state of the United States, like every state of Australia, had criminal prohibitions against abortion, and they were fairly absolute. they did allow, by common law decisions, judge-made decisions, exceptions where the very life of the mother was at risk. But other than that, protecting the mother, the fact that what was happening to an adult, and it was happening with competency and skill and care, and fully wished by the adult person involved, was irrelevant. And that was the position until the United States, down the judicial path, began to take a different course. In a case concerning the provision of contraceptive devices, which was seen as linked to abortion, the United States Supreme Court took a step of holding that a state law interfering in the provision of contraceptive advice and implements and other means was overstepping the mark. And to do that, the Supreme Court reached to the 14th Amendment to the United States Constitution. And that is an amendment which was basically enacted to bring recalcitrant states of the United States into line with the outcome of the Civil War in the United States. The states were not taking steps to respect and protect the African American members of their community, and the 14th Amendment was adopted, which essentially said that no person who is a citizen, either natural born or naturalized, of the United States will be treated without respect to their inherent privileges and duties. And so that was the 14th Amendment that became the hinge by which the Supreme Court of the United States developed its jurisprudence and eventually reached the case of Roe against Wade. Now, that decision was anchored in the 14th Amendment. And as a result of that, it led to a division of opinion in the judiciary in the United States. And there were some who never agreed with the application of the 14th Amendment, and others who said this is settled law and it gives constitutional rights to women in much the same way as a little later constitutional rights were given to gay people, both in the United States and Australia. Those two things have rather gone in tandem. And in respect of homosexual citizens, that led to the overruling of the sodomy law, which was the same law as we had in Australia, and of the earlier laws on homosexuals not being allowed to marry. Those two decisions of the US Supreme Court are anchored in the same theory of the privacy right, that matters that touch upon the rights of and privileges of individual citizens are outside the intrusion of government. And that is the debate that was decided by the decision last week in a case called Dobbs against Jackson Women's Healthcare, and that decision reversed the earlier line of authority in the United States. Now, on both those matters, we in Australia took a different path because our constitution contains very few constitutional rights. It never developed a Bill of Rights, and that was because the notion existed that our parliaments, being composed of elected citizens of our community protect those rights. And the result of that has been that we've had to go down the path of legislation, acts of parliament. And this was given an impetus in a decision by Justice Menhennet in Victoria. It was, as usually is the case, Victoria that led the way, depending on one's view about abortion and law on abortion. It was Justice Menhennet who expanded the notion in the common law and in the elaboration of the Victorian Act dealing with abortion to hold as a matter of law that where an abortion was carried out for the purpose of the welfare, well-being and life of the mother, that was not included in the statutory provision. And Justice Menhennet, his line of authority and reasoning led to similar reasons in other states of Australia. In New South Wales, a decision of Justice Levine. And the Levine ruling and the Menhennet ruling led to the removal of criminal law from this field in Australia. And the consequence of this was that we developed along a different line. Interestingly, Justice Alito's reasons in the Supreme Court of the United States last week expresses the real legal effect of what the Supreme Court majority did by saying they were returning the control of abortion in the United States to the people, meaning thereby to the people in the state legislatures. And that was how the majority saw what they did. So far, they have not held that you can't have an abortion at all. They simply held that, and this is the authority of Dobbs, that the determination of whether the abortion is legal or not is determined by the state legislatures. And the problem with that theory of the case is it took away established rights for 50 years that had been created by the American equivalent of the Menhennet ruling, the American equivalent of the Levine ruling, and took them away after 50 years of enjoying that benefit. And it's why Justice Clarence Thomas, who is the leading force in this, is contending that this has no authority in the text of the Constitution, should be reversed, and other things that have relied upon similar reasoning, such as the laws relating to the sodomy offence and the laws relating to equal marriage for gays and non-gays, was a matter that had to be returned to the legislature. And that hasn't really been explained in any of the programs I've seen on television. But between the viewpoints that are expressed by the majority and the minority in the US Supreme Court is a very significant difference in the view of the rights of the individual and the legal ambit of the power of the courts to give rights that will be protected by the law. And it's therefore interesting as a background for the matters that I'm going to discuss today, that this debate is so lively in the United States, and it's as well that we understand that it's also a debate we've had in Australia, but we resolved it by legislation, acts of parliament, and by judicial construction and interpretation of those acts of parliament, which were a construction that was beneficial and protective of the women involved. Now, because that was the case, I never found myself agonizing over the provisions of the Australian Constitution, as the judges in the United States have done. My tasks have been incidental to the legislation which has been enacted by state parliaments to provide the circumstances of abortion and to some extent the given, that is to say, the proposition that was not really in debate, that abortion might take place, but in accordance with the law as stated by Parliament. The first case that I had to deal with this was a case called CES against super clinics. This was a case when I was the president of the Court of Appeal of New South Wales. The case came before the court in 1995, which was just before I was elevated, as we say in the law, to the High Court of Australia in 1996. And as sometimes happens, there was a big division in the Court of Appeal when I was sitting on that case. The case concerned an unmarried couple who had become pregnant and through a series of mistakes or neglect, a surgeon had performed a tubal ligation in respect of the woman and had not clipped a fallopian tube, with the result that she became pregnant and she was concerned about that possibility. She was reassured by the surgeon that there was no chance and that she would not become pregnant, but she did. And she contended that her repeated inquiries, having led to reassurances, had effectively deprived her of the entitlement to take advantage of the Menhennet-Levine approach and to secure a lawful abortion. So that was the case of CES. But when it came to the primary judge, he rejected the contention, but it came up to the Court of Appeal, and Justice Ma, who was a senior judge of the Court of Appeal, upheld the primary judge and referred not to Justice Menhennet and Judge Levine, but rather to St. John's Gospel, which states that the birth of a healthy child is a great blessing, and that therefore the parents, in effect, should give thanks to God that they have had a healthy child, and they were certainly not entitled to any damages for the birth of the unwanted child or for the failure to the doctor to give advice to explain that they were entitled to an abortion. And he said that no damages at all were recoverable against the doctor. The second judge in the Court of Appeal, Justice Priestley, said that the matter had to be determined on the basis that the doctor had been negligent, and that the question was what damages would be recovered on that basis. And he said that the claim by the two parents for compensation for the costs that they were incurring and would incur throughout the infancy of the child could not be recovered in entirety. They could get something for the immediate costs of the delivery of the child and various other small amounts, but they weren't entitled to the large sum that they claimed because the mother could have put the child into the hands of the authorities for the purpose of having the child adopted, and that would restrict the amount that could be recovered to a period of weeks, and after that time, the parents were on their own. I was the third judge and the senior most judge in the case, and I didn't agree with either of the other judges. I concluded that yes, the doctor had been negligent, but no, the damages were not limited to putting the child to adoption, that was something that could not be demanded of her as a condition of recovery, and it was not founded in legal principles. And the consequence of that was that I concluded that the parents were entitled to recover the full costs of rearing the child to the age of 16, which was a substantial amount in those days. I think it was $160,000. So that was the difference in the court. And under the conventions, we had to find a resolution of that, because you can't send the matter away and say one judge says give nothing, another judge says give a little, and the president says give the lot. And the way that is generally resolved is to search for whatever is the common denominator. That is what is the common theme. And when I did that as president, I therefore, what we say, withdrew my preferred option and said that I would agree with Justice Priestley, because at least then the principle of the recovery was established, and the matter would be determined on that basis. And that unsatisfactory decision of the Court of Appeal of New South Wales came up to the High Court at about the time that I was elevated to the High Court. Now, tempting though it might be for me to sit in a case in determining a decision of my own, I had to disqualify myself, and so I did. And accordingly, the bench of the High Court that was convened was chaired by Chief Justice Brennan, who died a few weeks ago, a very great judge, the author of the Mabo decision on Aboriginal land rights. And many predicted that he would favour the view taken by Justice Marr, and maybe he wouldn't cite St. John's Gospel, but that would be informing his approach. However, as sometimes happens in these things, the best laid plans of mice and men gang off to Gley, and the parties went off and settled the case. And therefore, although it actually had begun in the High Court of Australia, it didn't proceed to an outcome. And so the issue was then lost in the sense that the opportunity was forfeited on that occasion. Notwithstanding that, about 5 years later, a case came before the High Court of Australia where there was no embarrassment on the part of any of the judges, and we could sit on it, and did so to the extent that the 7 justices of Australia's final court took part in the case. This was the case of Catanac against Melchior. And Mr. and Mrs. Melchior were very well and truly married couple. They'd engaged Dr. Catanac, a surgeon, and he had failed to clip one fallopian tube. And the result was that the mother became pregnant. And a consequence of this was that it was accepted that they were entitled under the law of Queensland, which was the case in this litigation, to recover for negligence. But the question became, what will be the damages? Because that hadn't been resolved below the High Court, except in a couple of cases, including the case of CES. And that hadn't been resolved in a clear manner. So the net result of in that case was that the court had to determine what should be done. The majority of the High Court held that the advice was negligent, that the negligence was found in the failure to warn the mother of the risk and then properly to diagnose the early stages of the pregnancy and give her the entitlement to secure advice on the termination of her pregnancy. A minority of the court, Chief Justice Gleeson, Justice Hayne, and Justice Hayden held otherwise. A minority held that no damages were recoverable, and therefore the majority view that the benefits were discounted and not taken into account. The suggested benefits of the St. John had talked about, and that the parents were entitled under our secular legal system to the ordinary consequences of the damage they had suffered. And so that was a matter that effectively was determined in favour of the view that I had taken in CES. And since then, a number of statutes have been adopted in Australia, which have dealt generally with the law of abortion and generally in favour of protecting the rights of the mother to an abortion, and adding to that provisions forbidding and punishing people for going within 150 metres of an abortion clinic to harass the people going in and out of the clinic in an attempt to dissuade them from availing themselves of that service. So the position in Australia was that by 2006, 16% of Australians said that abortions should never take place. 17% said that there should be more liberal entitlements to abortion, and 56% of Australians in repeated opinion polls at 2006 said that the law should be loosened up. The then present law should be maintained. But changes in attitude have happened in Australia, so that by 2009, 77% of Australians concluded that there should be abortion available, and therefore that was a factor to be taken into account in working out the damages that could be recovered for medical negligence resulting in an abortion. Now, there were two important cases that came to the High Court of Australia at that time, and both of them concerned the so-called wrongful birth or wrongful life case. These were the case of Harriton against Dr. Stevens in 2006 and Waller against Dr. James in 2006, which presented different sides of the coin, but a common problem. And the cases involved, in the case of Harriton, the birth of Alexia Harriton. She was born deaf, blind, mentally handicapped, and spastic as a result of having a misdiagnosed case of rubella, which had not been picked up by Dr. Stevens. And the result of that was that they claimed damages, and they came and sought a resolution of the entitlement to damages in their favour. In this case, unlike CES and the earlier cases, the child had not been a happy birth and a happy and healthy child, but was profoundly handicapped. And the common theme was that in both of the cases, that had the mother been informed accurately about the likely birth of the child, she would certainly have undertaken an abortion that would have been lawful, and she was denied that opportunity. And then the High Court divided on what the response to that particular development of the problem was. This was not a healthy child. This was a profoundly injured child. And the question was whether Mrs. Harriton could recover damages from Dr. Stevens. And the result in the end was that the overwhelming majority of the judges of the High Court, Chief Justice Gleeson, Justice Gummow, Justice Hayne, Justice Crennan, and Justice Callanan, and Justice Hayden, concluded that the proposition that was being advanced by the plaintiff, Mrs. Harriton, was untenable logically. That was so because the only way she could claim the damages was by saying that the life of the child was so profoundly damaged that the child should have been terminated. Not that it would be terminated in the ordinary course of the decision of the mother, but that this was a case where you were comparing a child being born at all and a child not being born. And effectively, the majority of the High Court of Australia held it's not logically possible for any person to be heard to say, I should not be here, and that you cannot say that, and consequently, the parents should not recover anything from Dr. Stevens. I was the sole dissentient, and effectively I was being completely consistent with my earlier decisions all along. And I said that labeling this as a case of wrongful life was a value-loaded proposition, and that the life had been born. It was not a case where you could wish away or think away the child's birth. The child had been born, and the question was whether or not the child and the parents on the child's behalf could recover damages so that the profound injuries which would lead to tremendous loss and costs to the parents could be recovered. I said the issue is not that of illogic between a life without disability and a life with some disabilities. This was a case of who has to pay for the negligence which was accepted by the doctors, and that in these circumstances, the so-called illogic didn't prevent the parents from recovery. I pointed out in my reasons that the illogic of the majority view was the more profoundly and grossly profoundly and terrible were the damages to the child that they can't recover anything, was a reversal of the logic of the law, which is that the greater the damage, the greater the recovery. And that is where the decisions of the High Court have so far terminated this debate. It won't come as a surprise to you to think that I would say I was right all along in the view that I took, and that my colleagues in their different combinations and for their different reasons were incorrect in their analysis of the matter. But I will be interested to hear what, if anything, the audience today thinks is the correct solution to that. And of course, I've put my point of view, perhaps with a little more power, and my colleagues would have put their propositions with a little bit more persuasiveness than I've put them. But it gives you an outline of how your lives intersect with our lives in the law, and how important is this area of the law, as can be seen on your television screen if you tune into any news broadcast at the moment, not just in American networks, but Al Jazeera. The big story of the day are the protests in the United States. And I've tried to explain how that's because America took a different line in the development of its law on abortion from the line which we took in Australia. And I actually knew Justice Menhennet. He was a very, very lovely man, and he would be astonished if his ruling had caused a huge revolution, including in public opinion, because he was quite a conservative judge of the Supreme Court of Victoria. He just reasoned the case and expressed his view, and that altered practice in Australia, and that practice has developed to the state where, in Australia at least, acting through Parliament, we've been able to solve most of the problems that have occurred, but not when there is negligence. We solve that by the decisions of the highest court, but there were important dissents, and most important, mine.
Thanks, Michael. Can I just bring your attention? There's a comment in the chat, and there's a question, a large question from Michele, which I think is on many people's minds. So the comment from Marianne was, it's up to the people to decide whether or not abortion is to be legalised. As the US is a democracy, this right to abortion should be determined by the elected representatives and not by the judiciary. I think that's what the recent Supreme Court decision means, and I think that's what you explained earlier today. But if you want to comment on that any further.
Well, in terms of democratic theory, I agree with that. But in the United States, democratic theory has to bow to the Constitution. And the Constitution in the United States, but certainly not in Australia, doesn't have any provision like the 14th Amendment. The real debate about the 14th Amendment in the United States is whether it should be confined to a case like abortion, but it speaks more generally to equality and self-empowerment. And that was the view that was taken in upholding the right to gay marriage and the right to get advice on contraceptives and striking down the provisions in the United States of state laws which forbade people from getting married because they're of a different race. The irony of all this is that the leading proponent of this view of the US Constitution is Justice Clarence Thomas, and he is himself living in, and has for many years, a relationship with his wife, Ginny, who is a rabid supporter of anti-abortion, but might find that the logic of her husband's reasoning on the 14th Amendment may lead to a question as to the validity of their marriage. People say, most people, certainly many politicians, including on both sides of politics, John Howard, for example, on one side, and Bob Carr on the Labor side, that it's better to solve these problems in Parliament. And that, I take it to be the question which is in the chat box. And generally speaking, I think that's right. But we in Australia have been riddled since our earliest colonial days with a whole series of laws and enactments of state and federal parliaments which have been terribly unfair to minorities, like the laws relating to Aboriginal land rights, like the laws relating to disadvantages of women, and like the laws relating to LGBT rights. And in the United States, they resolved this generally by an interaction, or a conversation, if you like, between the state legislatures and the federal constitution. But we don't have an active dialogue because it's all there with the states, and the states in their parliaments have not always been enlightened in the way they have dealt with issues.
And that probably brings me to the question in the chat, which is, the decision of the Supreme Court in the US will further disadvantage marginalised groups and the poor. The combination of the rising conservative Christian power, increasing economic and health inequality, and rising gun ownership and violence is worrying. Where do you feel the US will end up over the next 10 years? And can they find a way out of this through their current political and legal systems and processes?
Well, it's the sting of that question is in the tail. How do they get themselves out of this situation? Because if you analyze the justices and their divisions, the three justices who dissented, Justice Breyer, Justice Kagan, and Justice Sotomayor, were all appointed by Democrat presidents. And all the other justices, 6 of them, including the Chief Justice, were appointed by Republicans. So this is a pure political division on the court. And that is something which we haven't generally had in Australia. You do get slight differences in the appointment of more liberal judges by Labor governments and more conservative judges by coalition governments. But how the Americans can get out of this, given that it's all rooted in the Constitution, the real issue will be if future Democrat presidents appoint and get through the advice and consent provisions of the Constitution for federal judges, how will that change the balance in the Supreme Court? Most of the justices of the Supreme Court of the United States who sided with the abolition of Roe versus Wade are sprightly, and if not young, at least they're going to be around for some time. And they won't be in the slightest influence, not the slightest, by the scenes on the television. They'll say, well, they just don't understand. We're giving back the power to them. But the real test will be a coming test, which is that the logic of Justice Thomas may result in the passage of a law which forbids abortion, and does so on a historical analysis rather than on a policy analysis of where the law should stand. And if you go back to 1776 in the United States, well, Justice Alito has said embarrassingly, abortion was not dealt with by the criminal law in most places, states, most colonies, but it very quickly moved to prohibition. And so how that is going to be worked out remains to be seen. I would think there will be a lot of pressure on presidents, including Republican candidates for president, to restore the status quo ante. But if that doesn't happen, there'll be pressure pushing in the other side. The only other solution would be to increase the numbers of the justices of the Supreme Court so that a Democrat president can appoint a number that will outvote the Republican appointed justices. And I don't think that that is something it hasn't been done in the past, and I don't think it's something that presidential candidates would be willing to own up to or do.
Maybe a follow-up question to that, and then there's one other one. So can their constitution be amended in this regard by Congress and the president?
No, it requires an even more complicated amendment provision than we have in Australia. In Australia, there have been, over the years since 1901, 28 proposals for an amendment of the Constitution of Australia, and only 8 of those have been adopted. So it's quite hard to get an amendment to the Australian Constitution. In the United States, their system requires a proposal by the federal authorities, the president, supported by the Congress, and then a supermajority of the legislatures of the states. They don't go directly to the people, they go to the state parliaments in the United States. And that has also proved extremely hard to get through Parliament. There was one provision which was advanced. The most recent attempt was women's equality, and that didn't get sufficient number of state legislatures supporting it to put a provision for women's equality. But they did have and do have the 14th Amendment. So it's all a question of how you spin out the words that everyone shall have due process of law and shall have their rights and privileges unaffected by state law. That was meant to deal with the slavery issue because the states were the problem. But it has been interpreted to give a right to privacy and a zone of individual rights that the state legislatures cannot interfere with. And that is what Americans have grown up with. It's actually interesting to see one of the only state governors who acted to strike down President Trump's attempt to seize the victory in the last presidential election. In explaining that, he said, "My oath is to the Constitution. I regard that as a sacred document, and I will not breach it." Well, now it's not a sacred document. It's the work of human beings, and it's a political document in a secular community. But we all know the United States doesn't have the levels of support for abortion or for gay rights that we have in Australia. And therefore, the reality is that this decision in the United States is going to make it extremely difficult in their law to provide for a change. And women are just going to have to hop in cars and travel lengthy distances to get to a state where they can get an abortion. And even that might come under attack by the Supreme Court, which holds that you cannot get an abortion, period. And that is the next step in this saga.
Well, there's a couple more questions in the chat, but I'm conscious of the time. We have about 1 more minute left. So I might instead use the time to thank you for talking to us today. It's been a great tour of judicial decision-making and understanding the processes. And I think it's been very topical given the events over the last week. So we've really appreciated you coming to talk to us today.
Well, I hope it was of some interest and use to you. It's a little distant from your daily chores and life, but this is the world we live in. We're all connected and we all have to pay attention, especially if it's the United States.
I think that's a very good note to end on. So thanks again.
Thank you, Michael.
Thank you.
Thank you very much. I'll just try and get my mouse to work. There we are.